Please, the swearing-in ceremony will take place in a short while from now. Please switch off your mobile phones or put them on a silent mode. Swearing-in ceremony being an official function, there shall be no clapping after the swearing.
May I have your Lordship's permission to commence the proceedings? Communication has been received from Honorable the President of India. The communication reads as follows. July 16, 2024, 25th Ashad, 1946 Shaka. In pursuance of the provision contained in Clause 6 of Article 124 of the Constitution of India, I, Draupadi Murmu, President of India, do hereby appoint Dr. Justice Dhananjay Yashwant Chandrachud, Chief Justice of India, as the person before whom Sarvasri Justices Nomi Kapam Kotishwar Singh, Chief Justice, High Court of Jammu and Kashmir and Ladakh, upon their respective offices as judges of the Supreme Court of India, make and subscribe an oath or affirmation according to the form set out for the purpose in the third schedule of the Constitution of India, signed by the President of India. Warrant of appointment of Honorable Shri Justice Nomi Kapam Koteshwar Singh reads as under. By virtue of the power vested in me by Clause 2 of Article 124 of the Constitution of India, I, Draupadi Murmu, President of India, do hereby appoint Shri Justice Nomi Kapam Koteshwar Singh, Chief Justice of the High Court of Jammu and Kashmir and Ladakh, to be a judge of the Supreme Court of India with effect from the date he assumes charge of his office. Given at Rashtrapati Bhavan, New Delhi, the 16th day of July in the year 2024, 25th Ashad, 1946 Shaka, in the 75th year of the Republic of India. Signed by the President of India. May I now request Honorable Shri Justice Nomi Kapam Koteshwar Singh to take oath.
I, Nomi Kapam Koteshwar Singh,
having been appointed a judge of the Supreme Court of India,
having been appointed a judge of the Supreme Court of India,
do solemnly affirm
that
I will bear true faith and allegiance to the Constitution of India as by law established,
that I will bear true faith
of India,
that I will uphold the sovereignty and integrity of India,
that I will do
the best of my ability, knowledge, and judgment,
perform the duties of my office without fear or favor, affection or ill will,
perform the duties of my office without fear or favor, affection, or ill will,
and that I will uphold the Constitution and the laws.
and that I will uphold the Constitution and the laws. Thank you, sir.
Warrant of appointment of Honorable Shri Justice R. Mahadevan reads as under. By virtue of the power vested in me by Clause 2 of Article 124 of the Constitution of India, I, Draupadi Murmu, President of India, do hereby appoint Shri Justice R. Mahadevan, Judge of the Madras High Court, to be a judge of the Supreme Court of India with effect from the date he assumes charge of his office. Given at Rashtrapati Bhavan, New Delhi, the 16th day of July in the year 2024, 25th Ashad, 1946 Shaka, in the 75th year of the Republic of India, signed by the President of India. May I now request Honorable Shri Justice R. Mahadevan to take oath.
I,
R. Mahadevan,
having been appointed a judge of the Supreme Court of India,
having been appointed a judge of the Supreme Court of India,
do swear in the name of God
do swear in the name of God
that I will bear true faith and allegiance to the Constitution of India as by law established,
that I will bear true faith and allegiance to the Constitution of India as by law established,
that I will uphold the sovereignty and integrity of India,
that I will uphold the sovereignty and integrity of India,
that I will duly and faithfully and to the best of my ability, knowledge, and judgment
that I will duly and faithfully and to the best of my ability, knowledge, and judgment
perform the duties of my office without fear or favor, affection, or ill will,
perform the duties of my office without fear or favor, affection, or ill will,
and that I will uphold the Constitution and the laws.
and that I will uphold the Constitution and the laws.
They are all connected to Guwahati.
Yes.
He is the Bangar brother-in-law, right?
May I have your lordship's permission to conclude the proceedings?
The court will assemble for judicial work at 11:15 a.m.
क्लेम में कोई प्रॉब्लम तो नहीं होगी ना?
डोंट वरी सर, कार रिपेयर से लेकर क्लेम सेटलमेंट तक पॉलिसी बाजार हमेशा आपके साथ होता है।
पॉलिसी बाजार पे कार इंश्योरेंस कंपेयर करके 8,000 रुपए तक बचाओ।
After switching to Zoho payroll, we are using just 1 to 2 hours for this smooth process of this payroll activities. We definitely want other business units to try and give it a shot.
Before we begin, I must share with all the members of the bar that we are very honored to have in our midst Justice Antonio Herman Benjamin, a very distinguished scholar and international judge from Brazil. He's due to be sworn in as the Chief Justice on the 22nd of August this year. So we're very privileged to have Justice Antonio with us. He's a great friend of India, one of the foremost international experts on the law relating to the environment. So he's just come back from a trip to Srinagar, Sonmarg, Kargil, Leh, and back. So he drove all the way. He's very fond of India, and we're just sharing with the colleagues what his experiences about that trip. So we welcome you in our midst.
On behalf of the bar also, my lord, I welcome the honorable guest to this.
Thank you. So we'll start with our daily board.
Lord, may I just mention, Lord, I have circulated a mail. The reason is, my lord, my lord, I mentioned it before vacation. Lordship said it will be listed. It was not listed because it's an old matter. Regarding a PGI admission matter, my lord.
All right, I'll list it, yes.
My lord.
Lordship, may I mention?
Just circulate an email and I'll attend to it in the afternoon today. Just circulate an email and I'll get your matter listed as quickly as possible. All right, let's see the first case.
My lord, may I mention item 40? My lord, by the time the matter reaches on board, my lord, NTA can be directed to produce the original OMR of the.
Nothing of the sort. Wait for the matter to reach. Yes, item one.
May I please, my lords? In item 1, my lords, this is a bail plea, my lords. The petitioner is in custody since 10th of February 2022.
In possession, you were alleged to be in possession of 80 kilograms
I
of
was
copy.
not found on the location, my lord.
You are not. They say that your identity cards were found in the vehicle.
No,
You're
not the identity card, my lords.
You're not the registered owner of the
I am
vehicle.
not the registered. I have placed it on record, my lords. The registered owner says in his cross-examination, he has been cross-examined.
Allegation is that the vehicle has been transferred in your favor.
He says, but in the cross-examination, he says he cannot confirm if the vehicle that has been alleged to be found by the police is the same vehicle which he sold to me, even otherwise, my lords.
All right, we'll issue notice here and keep it after 2 weeks. Serve the standing counsel for the state of Madhya Pradesh.
I'm most grateful.
Issue notice, returnable on liberty to serve the standing counsel for the state of Madhya Pradesh. He has been denied, Antonio.
Most grateful, my lords.
Item 2.
Very short question is what is the
There's a
relevant?
delay of 235 days.
There is a delay, my lord, because
Why
of
should
the
we condone
evidence.
the delay?
My lord, there was.
And look at it this way. When they first filed their claim before the tribunal in Madhya Pradesh, you objected to the jurisdiction of the tribunals, relying upon the judgment in VA Tech. True, the judgment in VA Tech has been overruled subsequently. But at that stage, at your behest, he was sent to the arbitrator. You didn't object to his
By the
jurisdiction
High
before
Court,
the arbitrator.
By the Honorable High
Right.
Court.
But then you never objected before the arbitrator. Now there's an award.
It's a matter of record that we objected only at the stage of 37, my lord. I
37.
cannot
So-
quarrel with that.
And we'll dismiss it. What we'll do is we'll dismiss it on the ground of limitation so that it doesn't become a precedent in any other case. And we'll keep the question of law open. There's a delay of 235 days in filing the special petition against the judgment of the Madhya Pradesh High Court dated 9 December 2022. Full stop. There is no satisfactory explanation for the delay. Full stop. Hence, the petition is dismissed on the ground of delay. However, we clarify that since the bar of limitation has intervened, it has not become necessary for this court to express any opinion on the question of law raised.
It will remain open, my lord.
Which is kept open. We shouldn't say it's open because actually the question of law is decided in your favor
My
by
lord.
our judgment of
Lions.
2018.
Lions.
Because the judgment in VA Tech has been overruled by our court.
That is
So
there, my lord, but
if we keep it open, we are tacitly then casting doubt on our judgment. The question of law is in your favor. Just that we are not interfering in this case only.
at this stage, my lord, if I may only.
They will
point
say it's
out-
the question of law is kept open. Fair enough. You want it, we'll give it to you.
I'm very grateful, my lord.
Please, my lords. My lords, this petition has become infructuous because subsequent developments have taken.
Counsel appearing on behalf of the petitioner states that the petition has been rendered infructuous by subsequent developments.
I'm sorry, I want the question of the law to remain open, my lords. Simply being, my lords, because this is for the second petition, my lords, pursuant to a settlement agreement. And Lordship's court has.
Always open queas. Nothing is concluded by us. We're just saying that it's infructuous. Item 4.
My lords, the matter will ultimately be the Lordship's court only. So I'm just.
So it's always open queas. We are saying it's disposed of as infructuous. It can never bind a future bench.
I'm very grateful, my lords.
In this matter, admittedly, the NCLT finds that my claim and my allotment to the flat is reflected in the information memorandum, which is the basis of any resolution plan. And it is showing in the record.
What about delay?
Yes, my lords. On delay, my lords, admittedly, I am not present when this pronouncement is made. My lords, the matter is reserved 3 months back. It comes in a pronouncement, my lords. My appearance is not there. I have vehemently said that I was not present. It is uploaded, my lords, and
What is the date on which it is uploaded?
my lords, it is uploaded on 22nd of August 23, from which, my lords, I am within limitation, excluding the certified.
You were not present. Were you a party?
Yes, it was my application, my lords. On my application while reserving.
But then if it's your application.
Yes, my lords.
Then can you say that I was not present? I don't know because.
So, my lords, the arguments happened, the order stands reserved.
But it is,
not-
when is the order pronounced actually? It's not pronounced at all.
Not on the dates argued, my lords, not on the dates heard. It comes up in the list 3 months after for pronouncement.
22nd August.
No, my lords, 11th of August. 22nd August is when it is uploaded and which is when I gain knowledge of the order. And I, my lords, file immediately. I filed the appeal immediately.
Learned counsel appearing on behalf of the appellant submits that that in the application which was filed by the appellant, though the order was passed by the National Company Law Tribunal on 11 August 2023.
Yes.
The order was uploaded only on 22 August 2023. Hence, it has been urged that the appeal which was filed on
The appeal was
October 2023.
Yes. My lords, 10th October 23.
10 October 2023 would be within the period of limitation of?
My lords, 61-2.
The limitation. We'll issue notice.
Great.
Returnable on.
My lords, may I only make one request? The resolution plan basis which my application was dismissed even to date has not been approved by the NCLT. Now, my lords, may I only request for an interim stay until...
We'll make it returnable in 2 weeks.
Great.
Stay everything. Serve Dusty and come.
So good.
Yeah. See, in this case, the NABARD, though initially it said that, there may be certain irregularities in the functioning of the bank. Subsequently, it filed an affidavit before the High Court stating that the resolution of the board was proper and that there were no irregularities. Ultimately, this was a public interest litigation. You brought some grievance to the attention of the court. The court has felt that it is not necessary to interfere.
Page 368 may be seen for a moment.
What is that?
Ordered by High Court, Honorable High Court.
The earlier High Court, the earlier order.
Yes, Lord. It says, Lord, pursuant to previous order, action taken, report on behalf of the NABARD has been placed on record. Prima facie, certain allegations were stated to be true.
But that is prima facie. Subsequently, NABARD files an affidavit and says that we have now looked at it and there's nothing.
Later, Lord.
Anyway, as a PIL petitioner, your duty was to point it out to the High Court. High Court went into it. NABARD is a national bank for rural development. They file an affidavit. Now, why should we?
But the error is page 389 may be seen, Lord. Uttar Bihar Gramin Bank, as well as not the sponsor bank, Central Bank of India was directed to take decision on this erroneous activity. But that is my.
But look, ultimately, as a bank, it is regulated by the state authorities, since it's a state bank, as well as to a certain extent by the Reserve Bank of India. Why should we presume that they will not look into the any regulatory failures in the bank?
Lord, may I submit, not any fraud above 3 crores, Lord, is directed to be investigated by CBI. But here the quantum is not above. More than not 500 crores. Not that is.
Sir Counsel, we are referring to the affidavit filed by NABARD dated 21st February 2024, where the averment is that it is humbly submitted that as per the specific directions dated 18 January 2024 of this court, the instances pointed out in the special audit report were scrutinized. On scrutiny, respondent number 4 is satisfied with the resolution of the board of UBGB that the guidelines of fraud are not applicable to the present matter, audit report, and therefore the matter is not required to be referred to local police/CBI as per clause 9.1 and 9.2 of respondent number 4.
Lord, may I submit, Lord? Initially, Lord, 13.
I think we made our point clear. I think we'll not entertain it further. It is a PIL after all. Yes, dismissed. Item 6.
Okay.
दोस्तों 2000 की नोट बंद हो गई इससे पहले 1000 की नोट बंद हो गई थी। आप कहोगे सर पता है, ये आप क्यों बता रहे हो? जो भी चीज आउटडेटेड हो गई है ना, वो बंद हो जाती है, और बंद होने के बाद उसकी कोई रिस्पेक्ट, कोई इज्जत नहीं रह जाती है। इसी तरीके से अगर आपने अपने आप को अपग्रेड नहीं किया, आज अपने MS ऑफिस के अंदर चैट GPT और AI यूज नहीं किया ना, तो एक दिन आपको भी आपके ईमेल पे एक लेटर आ जाएगा जिसमें बोला जाएगा कि भाई आपकी